And off we go. Some disclosures. We have just a couple of things to say. I'm a former co-chair of an advocacy group, a physician advisory committee for an advocacy group called Dying with Dignity Canada. I'm currently employed by a faith-based institution, for which I'm very grateful, and which is an interesting sort of mix of disclosures. If you want to think about that, I've had consulting fees from organizations to prepare educational material around assisted dying, and I was an expert witness in 2 of the cases here in Canada. So obviously, I have a bit of a theory, and I have some opinions on assisted dying, but I'm not here to try to change anyone's opinion on assisted dying. I'm certainly not here to tell you that there's, to advocate for any particular set of laws, one over another. Overview, generally what I want to talk about is talk first of all about the data and who is receiving MAID in Canada. We call it MAID, of course. Why are they requesting MAID, which is of course an important question on many people's mind around this issue. I want to talk a little bit about what we have, what information we have in terms of regulatory oversight and reporting, and talk about some of the effects on palliative care. I'm a palliative care physician. This is something of great importance to me. So I think we've already had a fairly a comprehensive introduction to some of the laws and some of the legal criteria around assisted dying and discussed them. Canada, a little bit more broad than what's available in the States. So legalized MAID for competent adults who clearly consent to the termination of life, grievous and irremediable medical condition, including illness, disease, or disability, and this was all defined by the courts, and who is enduring suffering that is intolerable to them in the circumstances of their condition. When MAID was ultimately legalized, so court in Canada, obviously the courts can strike down a law similar to the U.S. We have our courts have that ability. It's not true of every country, but the bill that was passed in response to it added a 4th criterion to these criteria, which was that they had to reach a point where their natural death had become reasonably foreseeable. After another court challenge that confirmed that was not actually part of the original court decision, another bill was passed, Bill C7, which established 2 assessment pathways, right? So you have one pathway for those whose death is considered reasonably foreseeable, so no actual number put on that. And previously there had been a 10-day reflection period, but could be shortened in the event that somebody was at risk of dying or losing capacity. For the shorter pathway, they actually eliminated the actual reflection period simply because of some of the delays involved in getting the process started, that really people were just not finding that there were people for whom the reflection period needed to be 10 days after the written request, because it had been essentially a very long reflection period prior to the official initiation of the pathway. There is now also something called an optional waiver of final consent, which is used in very rare cases, about 1% to 2%, where somebody is eligible and is at risk of losing capacity or fears that they're losing capacity. They can actually sign final consent in advance that if they do lose capacity, that somebody can go on and perform MAID. This was to meet, this is known as Audrey's Amendment. It's to meet the request of some people that felt really distressed at the prospect of losing capacity and thus went ahead with MAID earlier than they might have otherwise wanted to do so, just for fear of losing capacity. So this was felt to be very reassuring to people. These track 2 cases, which are for people whose deaths are not reasonably foreseeable, they establish a much longer reflection period of at least 90 days. And in this case, one of the assessors has to have expertise in the condition that's causing suffering, right? So changing safeguards for the shorter pathway and additional safeguards for the longer pathway. There had previously been a requirement for 2 witnesses, now there's 1. And mental illness is now, so the mental illness was actually, and the courts really were quite clear that mental illness was not excluded from eligibility, but in the bill it was formally excluded as a sole underlying medical condition with a 2-year sunset clause. That was extended by 1 year, a year ago. And now the government has just tabled legislation to extend it another couple of years because many of the provinces have written letters saying that they're just not ready. There was a hullabaloo about that. I can give you more details if you want, but I don't think it's really important for the conversation that we're having here today. So the questions on a lot of people's minds are who is receiving MAID? Is this different than the overall population? And most importantly, some of the concerns and questions that got raised in the previous discussions, is MAID being driven by poor access to palliative care, poor access to timely or high quality palliative care? Is there a question of poor supports? Are people having support needs that are not being met? And is that driving MAID? And so structural vulnerability, socioeconomic deprivation, whatever metric you might want to use to measure a vulnerable population. I can tell you a little bit about what is known. So I'm going to try to use the most up-to-date numbers as best I can. So Canada produces federal reports, and here's what the numbers have shown in the last report that came out just a couple of months ago. It covers 2022. It's published in 2023. The numbers are broadly very similar to what we've seen for the past 4 years of Canadian federal reporting. So a very high percentage where palliative care services were engaged already with the individual. And for the majority of them, well, half of them, it was more than a month prior to their MAID request, which in turn would have been some time before their natural death. So this is actually a relatively early palliative care involvement compared to a general population. And in terms of disability support services on the right, about a third of people were felt to need disability support services, of which the large majority were receiving it. So if you do the math, and unfortunately they always do the math backwards here, so you have to calculate it yourself. But if you look at the number where the person was not receiving palliative care, and in the opinion of the physician providing the care, filling out the form, that they really did not have access to palliative care services, that number is 323. That's about 2.4% of the population. Of those who had needed access to disability supports and did not have them, that's about 1.5%. So again, not zero. Really be good if it was zero. But these are actually very, very low numbers. Very low numbers, certainly compared to population average, which, looking at these numbers, it makes it very hard to argue that MAID in Canada was being driven really by poor access to palliative care, poor access to timely palliative care, or poor access to needed disability supports. I'm going to come back to that in a second. We did a deeper dive into Ontario data. So Province of Ontario is about 40% of the Canadian population. We have a lot of administrative databases that can tell us a bit about the people receiving care and many different aspects of the care that they receive. And we did a comparison of those who received MAID with those who did not receive, who died without receiving MAID, and found a couple of really important findings. That people who died receiving MAID were substantially more likely to be from the highest income quintile and less likely to be from the lowest income quintile. They were really dramatically less likely. I'm circling with my laser pointer. Dramatically less likely to be institutionalized compared to the population average, right? So much, much lower. They are more likely to be married, less likely to be widowed. There was another study that looked at a sort of adjusted analyses, looking at many different factors, comparing the richest, the wealthiest quintile to the poorest quintile, and that the poorest quintile was across every demographic and illness subgroup less likely to get MAID than the richest quintile. Now, one of the comments from the federal reports that people sometimes comment to say, look, palliative care, when the assessors are filling out the form saying palliative care wasn't involved, that's all just self-reporting and you can't rely on that. In our study in Ontario, that information was being collected actually by what are called nurse investigators from the coroner's office. So in Ontario and in all of the large, most populous provinces in Canada, every MAID death is reported to an official reporting body. In Ontario, that's the Office of the Chief Coroner. And they have nurse investigators that will look into every chart and come to their own decision about whether they felt palliative care was involved. And the number that they came up with was 74% had palliative care involved prior to the request, 77% at the end of MAID. So almost exactly the numbers that the self-reported federal reports came up with, suggesting that, these are probably, again, we can disagree, reasonable people can disagree on what they would consider palliative care or not palliative care. But if people are coming up with very consistent numbers, that's I think, a reasonably good form of validation. Also, of course, how does one decide the adequacy of palliative care or the adequacy of support services, right? So there is actually no objective metric for access, right? I can tell you what someone got and I can tell you what someone did not get, but if they did not get it, I can't prove to you that they did or did not have access to it, right? So that's something that's always going to be somewhat subjective. So we kind of have to answer that question in a bit more indirect way. So one of the things about palliative care and end-of-life care is that there's a real dramatic difference between the types of end-of-life care received by people with cancer and received by people who have non-cancer illnesses. So for no rational reason, there's a very rational reason, but for no patient-centered reason, palliative care services and supportive services are heavily tilted towards cancer populations and very much tilted away from non-cancer populations, right? So it's not a perfect natural experiment, but certainly if you wanted to see, it's a common comparison where we look at end-of-life care received by people with cancer and non-cancer, et cetera, as a surrogate for adequacy or quality of palliative care, timeliness of palliative care. It's not an unreasonable way to do that, because we know that palliative care services, so for example, in Canada, people with lung cancer, dying of lung cancer, are far more likely to receive palliative care services and home physician visits than people dying of COPD. And if you look at cancer versus people dying of organ failure, they are twice as likely to get any palliative care services before they die. They are 4 times as likely to get palliative care in the community as opposed to in the hospital. And their median time of first involvement of the palliative care service is about 3.5 months before they die, versus people with non-cancer illness is about 3 weeks before they die. So a dramatic difference. And again, this is not relating to quality of life or symptoms. When you do head-to-head comparisons, the studies routinely show that quality of life isn't different between the two groups. Symptom burden isn't different. It's just the way that the services are generated and the way the services are designed that people otherwise similar needs, one happens to get a ton more palliative care than the other. So if this was really being driven by timeliness or quality of palliative care, one would reasonably expect that, for example, there would be, since there are higher unmet needs in the non-cancer population, you should see higher rates of MAID in the non-cancer population. In fact, you see the opposite. Rates of MAID are somewhere between 3 and 8 times more common in cancer populations. And this is a trend you see around the world, right? And we've got a paper coming out about this. But again, this is really, if MAID was being driven by unmet palliative needs or timeliness and quality of palliative care, you really couldn't see this data. And this isn't subjective data at all. This is completely objective data. In terms of supportive care needs, you can do a similar comparison. So this is a US data, Joan Tino's study and Joanne Lynn's study looking at dependency, right? So on the y-axis here, you have level of dependency. So the ADL score is the number of activities you need help with on a daily basis. The x-axis here are the months leading up to your death. So in the year prior to death, and these lines show the level of dependency, the diamonds with the dotted line, this is cancer, and all these other lines are everything else. Now you notice that cancer is the oddball. So people who are dying of cancer tend to have lower support needs for pretty much their entire end of life period. Around 3 to 4 months, there's quite a big inflection point and a dramatic increase in their dependency. And that's why hospice services typically are built around cancer services, because this is a very predictable period. And this is, of course, when people cross over from being independent to being dependent. Now, if you look at non-cancer and frailty, you'll see that everybody dying of something else pretty much doesn't look like that. They tend to have much higher levels of dependency going on for a very long time before they die. And there's a lot less of a dramatic change near the end. But again, so you have the cancer population that on the whole, until the final 6 weeks of life, has dramatically lower support needs. And I've already shown you data that they get higher services. They might have much higher involvement of paid services, certainly in Canada. If service needs and unmet service needs specifically were driving the practice of MAID, you should be expecting to see much higher rates of MAID in this population, in these populations, and much lower rates of MAID in this population. Once again, you see exactly the opposite, and it's not even close. It's sort of a 3 to 8-fold higher rates of MAID in this population than this population. So again, based on the data that we have, again, you can't do randomized controlled trials to prove any of this stuff, but in terms of the objective data that we do have to analyze this, if you're concerned that MAID is being driven by palliative care access and quality, you would have to explain why people with the best access and the highest quality of palliative care also have the highest incidence of MAID. People are obviously concerned about unmet support needs or attitude about societal ableism. But once again, the people with the lowest support needs and the best access to services have the highest incidence of MAID. If you're worried it's driven by poverty, the wealthiest Canadians have almost twice the incidence of MAID compared with the poorest Canadians. So, if poor people, it's not to say that no poor people get MAID, but if poor people were driven by their poverty to get MAID, you would have a lot of trouble explaining why people who don't have poverty have twice as high the incidence of MAID. So when you talk about loneliness or institutionalization, again, all the numbers are in the wrong direction to support that theory. So what you can conclude is that although there may be individual cases where some of these things may be happening, that obviously is not what population data can show or not show. But it does make it very clear that none of these factors could be driving MAID to any substantial degree, quite the contrary. As a palliative care provider, what is palliative care utilization? So we had a recent report looking at changes in palliative care involvement over the past 6 years. So from the moment of legalization until 2022. So it encompasses a bit of the pandemic. you'll see the involvement of palliative care in any setting has driven it sort of a high 52% to 59%. So that's more than a 1% growth per year, which is actually quite a fast, rapid growth. Use of palliative care in home care has gone up dramatically, and dying at home with palliative care has more than doubled. Also, other end-of-life practices that are also reported in other parts of the country. In Quebec, for example, British reports has shown a dramatic increase in the use of palliative sedation. So again, as we've seen MAID increase, we've seen other things increase as well. People often ask, what is it? Why, why is it then that palliative care involvement would be so high in people receiving MAID? Why aren't we able to relieve the suffering? Well, palliative care really actually can do a pretty good job of relieving suffering and improving quality of life. But there is quite a gap sometimes between making something better and relieving it entirely. Right? So that's a really important gap. You can make something better, but if the suffering is still quite substantial, people may want MAID. But also important to recognize that the number, far and away, the most common reason that people request MAID is because of existential distress, not physical symptoms. And existential distress is a bit of a challenge because the effectiveness and the duration of the effectiveness of our palliative and psychosocial interventions for existential distress is, I would say, modest, would be, I think, generous. We really don't have very good, effective, and certainly easily scalable therapies to deal with existential distress. It is a big hole in our current armamentarium. But it would certainly explain why you can have a very high level of palliative care involvement, and yet people would still want MAID regardless. At the end of the day, it's a false dichotomy, right? You're not choosing between palliative care and MAID. Everybody should have access to this, but I think we have to be careful not to make the assumption that the gaps, there are obviously, substantial gaps in access to palliative care in Canada as there are in US and other countries. But this gap isn't what's driving MAID, right? So we should be making palliative care interventions more broadly available. We should be increasing funding for palliative care for everyone, but not with the expectation that it will drive down the practice of MAID. As if to underscore this, of course, in Canada, a very substantial number of MAID procedures are performed by palliative care providers and in a palliative care setting, right? So that's important just to underscore the lack of the dichotomy there. I'm going to pivot to oversight. In Canada, of course, there's a mandatory review by the coroner in Ontario or in review bodies in other provinces. Generally speaking, they give feedback to the physician if they're concerned about any practices, they'll refer it to the regulatory college of our provinces. Families, if they're concerned, can also register complaints with the college, and the college, based on the nature of the complaint and what they're told, may choose to investigate. If there's a serious concern, it gets referred to something called so just Ontario as an example, there's something called the discipline tribunal, which can be appealable to a higher board. So there's a lot of pathways to make and pursue complaints if you're concerned about any aspect of care, MAID or otherwise. And the decisions of discipline tribunals and this HPAR board are actually publicly available on with discipline tribunal for the past several years has been available publicly. The case, of course, can also be referred to the police or the Crown prosecutor. In Quebec, they also have something called the Comité sur soins à fin de vie, which is like a committee that reviews these cases. These are 11 people, many non-clinicians. And just to look over some of the numbers then, just to see. So in the first, in the 4-year period of 2018 to 2021, I think it was a 3 or 4 year period, I forget, because they go on fiscal years. So it's a bit off. About 5,500 MAID cases. They flagged eligibility concerns in 4 cases. They referred those to the Collège des Médecins. I'm not sure, I can't tell if any discipline was taken in any of those cases. After Bill C-7 passed, there was a bit of a spike in the numbers. It went up to 15 in the following year, which is still about 0.5% of all the cases where there were some concerns, and it was sent on to the college, which would do investigations. And the Collège des Médecins actually felt that none of these 15 cases actually were they had any concerns that would require discipline. In Ontario, the coroner and the College of Physicians and Surgeons, looking on the websites, I've done searches, I can't actually find any cases that went as far as the discipline tribunal or any cases that were reviewed by HPARB, and I've got the references here. I haven't updated these searches in the past couple of months, but again, accounting for, until fairly recently. There's also in Ontario an ombudsman who issues annual reports, and of course everything in there that anybody would have brought to their concern. And in the 6 years of reports that I looked through, there was not a single mention of MAID as being a problem. Track 2 MAID, as you can see, of course, the use of MAID has increased steadily over the years since it's been legalized, and now with Track 2, the sort of longer prognosis MAID, and you can see it's a pretty small proportion, 2.2% in the first year, 3.5% in the second. It's important to note that in the first year, it was actually only 6 months. It was essentially only available for about somewhere a little over 6 months. And so, that 2.2 to 3.5% might not actually be an increase. In Ontario, we have data going up to the end of 2023, and it's actually down to about 2.5% or 2.8%, I think. So it's really kind of flattened out. Again, these are individuals, average age 73 years, not much different than the other tracks. Most are people with multiple sclerosis or Parkinson's disease, but often very complex conditions like multi-morbid frailty, multiple issues, lower involvement of palliative care services, which is, I think, to be expected for somebody who's got a disease that may have a very, very long prognosis. Of those who require disability supports, 91% received them. And we're going to have more comprehensive data available hopefully later this year. Notably, many more of the written requests were found ineligible about a little over a third of the time. So again, a lot of people asking who were not actually eligible. And again, there's been a lot of attention paid on Track 2 MATE. I do like to point out that these numbers are actually not that high. For a comparison, I do point out that according to official statistics, 200 Canadians are struck by lightning every year. So the incidence of Track 2 MATE is on the order of the incidence of being struck by lightning. And for any of you who've ever been to Canada, it's kind of white and snowy for about 6 months of the year and not so much lightning. So really, you only have 6 months of the year in Canada to get hit by lightning if you want to. This is not a very common event. I'm not saying it should be ignored, but the attention paid to it is a bit disproportionate. There have been a number of stories in the newspaper that have made the rounds, and people from other countries send to me, and people in Canada send to me, say, oh, what do you think of this? Unfortunately, a number of the stories about concerns that have been raised have sort of fallen apart quite spectacularly. So there was a famous case of somebody with chemical sensitivities, multiple chemical sensitivities, who, according to this story, chose medically assisted death after a failed bid to get better housing. The patient who was interviewed for the story actually got so upset by the story that she wrote another letter and she ultimately received MAID, but her MAID provider actually sent this letter into the parliamentary committee reviewing it, essentially saying how upset she was at the court, how her case had been misrepresented. That really, she wanted housing so she could have a safe place where her illness wouldn't get worse, but then she would be trapped in that house. It was really a question of whether her illness condition deteriorating or her social isolation from her illness was the main driver here. But again, certainly not as the case had been presented. There was a very famous gentleman named Yves. Yves was profiled in Montreal newspaper. This is a gentleman born many, many years ago with cerebral palsy at a time when very few people with severe cerebral palsy survived. But he survived and thrived, went to university, and actually raised a whole pile of money that now is used as scholarships for people with conditions similar to him. Really a remarkable individual. But like many people with his condition, as he got older, he got a lot of chronic medical problems that got worse, and he was repeatedly having to be hospitalized with decline. But he was steadfast that he wanted to stay at home. And at one point, he had gotten to the point where he had 28 visits, so 28 scheduled contracted visits from our home care service, and they still weren't able to keep him at home because of the fragility of his medical condition. Now, he was, I put the French up here, quoting from pourri à l'os, which basically means crap, like translates as crappy services. And he had a team of 3 dedicated friends. He had no family anymore, but 3 dedicated friends who took care of him. And they would say, you can't say that he didn't have any bad services, but that he didn't have good services, but when he had a bad one, he never forgot about it and would always complain. And another who said he knows it, that he doesn't have any more quality of life. It's really diminished, and the elastic is stretched to the max, essentially was the term that they're using. So again, from his perspective, he felt like the home care service had let him down, and this is why he was asking for MAID. From another perspective, you can see why people might think that that's, it may be more accurate to say that his medical conditions had really deteriorated to the point that he simply could not be stably sustained outside of a hospital, and he wasn't willing to live with that quality of life, and he requested MAID. The famous story of an ethicist who apparently offered assisted death or felt somebody was sort of being offered inappropriately. I do know a bit about this case, and this case, I think you have to read the transcript of this case. So the patient himself, who recorded surreptitiously this conversation, and the transcript was put out. According to the article and the transcript, Foley tells the man that he's always thinking he wants to end his life. So Mr. Foley was the one who clearly raised the question of ending his life. And the ethicist responding to this as ethicists do, neutrally presenting options, and said, would you think of applying for an assisted death? And then makes it exceedingly clear, don't get me wrong, I'm saying I don't want you to be here wanting to take your life. This is the case that's being sold around the world as ethicist coercion or ethicist inappropriately offering assisted dying. I think you have to sometimes really check the facts in some of these stories, because there's often a big departure between the headline and the content of the story itself. Are ineligible patients receiving MAID? Again, I think when some people come forward with stories and family members, some common themes: non-cancer illnesses, family members that were estranged, history of mental illness or substance abuse, none of which, of course, invalidates your eligibility for MAID, but these are the things that tend to show up. I think there is a scope for legitimate disagreements about eligibility and the effectiveness of treatments, but you have to understand, when someone has been seen by multiple specialists, including a geriatric psychiatrist who feels that the person had decisional capacity, it's hard for someone on the outside to look at that and say that they must be heavily concerned by this, right? These are people who are trained and experienced to do this. If we don't trust their judgment, okay, but then I'm not really sure why we trust anything at that point. And if it's reviewed by the coroner, the regulatory college, and the police, and they don't press charges, and people will say, well, then there's no oversight. Well, I would say, what's the oversight in your country? How do you know that your laws prevent abuses? Because those are the same people who would be investigating any concern or complaint in your case. So again, sometimes it's less about what MAID allows and whether you have any trust in the system at all. Some people ask about suicide rates and suicide contagion. I'm just going to put this up here. Canada in 2021 had the lowest suicide rate it's posted in over 40 years, after a decade or more of stable, gently increasing numbers, and then MAID was legalized, and it's now bottomed out. I don't think that has anything to do with legalizing MAID between you and me. I think that's an unrelated issue. But again, just anyone concerned that suicide rates might change or skyrocket, well, here you are. So in summary, it seems that Canadians are receiving MAID for the reasons intended, that there's pretty vigilant oversight, there's a high degree of compliance, palliative care utilization and funding are increasing rapidly. I think Canada, like many high-income countries, has problems with poverty, inadequate social assistance and supports, that we do have gaps in palliative care quality and access, and we do have issues with quality of care and loneliness in our long-term care settings and for our seniors. But all of these issues are definitely causing mortality and suffering, but none of them, all of them make death less likely, but all of them make death more likely, but make MAID less likely. So again, whatever the mechanism of connecting these structural issues with premature death and suffering, MAID is not that connection. So legalizing MAID didn't make this worse, and banning MAID wouldn't make it better. There's a report here and a reference provided. There was a parliamentary review done about a year ago. You can look at this if you want. I was asked specifically, just as part of the talk today, to respond to an article that appeared in the American Journal of Bioethics that was quite critical of the regulations in Canada. Rather than do that, I know the author, Daryl Pullman. I'm not going to beat around the bush. Daryl Pullman, I think, is a good guy, but I just think he doesn't really have a strong understanding of the topic, and I'll explain what I mean by that. It becomes a bit of a cottage industry in the ethics literature right now, I think, for people to write authoritatively about what is happening in Canada and all these various concerns that they have. And it's getting to the point where, it's almost hard as a Canadian who actually has experience with the system to provide any kind of counterpoint to some of this stuff. It got to the point where I was actually invited to appear before a parliamentary committee in the UK. So the UK was looking at different experiences. So they had a dedicated panel of 3 people to talk about the experience with MAID in Canada. And I was on that panel, and I was the only Canadian on that panel. I was the only person on that panel who had ever worked in healthcare in Canada. They had, and again, it just seemed bizarre to have to point out to people that if you want to ask about the experience of MAID in Canada, you probably want to get people who have some connection to healthcare in Canada. And I was the only one who did. And when I say legitimate connection, are you speaking to people who are requesting MAID, right? Do you actually have that genuine experience of knowing what it's about? Is this somebody who has literally written the same piece about MAID for 20, 30 years, come what may in terms of data from other jurisdictions? I think anybody who's following this, I would expect their opinion or their beliefs around MAID to have evolved somewhat over 2 or 3 decades, because we have gotten a lot of data. It's important to see, is this person citing data? Does the data say what they claim it says? Because again, there's often a gap between the headline and the content. Anecdotes, of course, are not data. And again, it's important there is a theoretical concern of what can happen when you legalize MAID. And the fact that it hasn't happened in the jurisdictions that we've studied doesn't mean that it can't happen, but you do need to know what has happened. Some of the things that kind of I notice in a lot of articles around this that I just want to flag, and again, I don't want to pick on Daryl because I think what he writes about are sort of common to a lot of things that I've read. The question, first of all, of delegitimizing the individual's role in the decision. So you'll see words like state-sponsored or state-sanctioned. Let me tell you that how hard the state in Canada fought not to legalize MAID. They made every attempt and used a lot of my tax dollars to fight against patients who were going to court through the courts to get the right to do this. The Attorney General fought them tooth and nail every step of the way. And those of experts who were testifying on behalf of the patients were working pro bono, and they were using our tax dollars to pay these individuals. The irony also is that many of the individuals who write things like state-sponsored and state-sanctioned were the experts themselves who were hired by the government to fight against it. So I don't know how long was the gap between when they cashed their government checks, the government funding that paid them to argue against this, and then they started arguing that this whole thing was actually the government's plan. But I think that there's a bit of a disconnect there sometimes. People talk about it being the physician's value, but I think it's probably more accurate to say that it's about when the physician's value accords with the patients, because more than 80% of Canadians feel that this is a right that they should have. I see now people love to talk about vulnerability, but the definitions get a little bit overbroad, right? So recently somebody called me to task for questioning whether being a woman was a form of structural vulnerability in a high-income country or a Western democracy like Canada. Because if that's true, we're talking about, okay, so it's any woman, anyone, any elderly person, anyone with a disability, chronic illness, people from BIPOC communities. You're getting to the point where like 80 plus, maybe 90% of the population is vulnerable. I don't think that that's an accurate depiction of vulnerability if your definition includes pretty much the entire population. And again, is the correct way to protect vulnerable people to simply restrict their autonomy to decide that they can't be trusted with their own decisions? When it's vulnerable to having decisions made for you, but you're also vulnerable to not getting the things that you do want. And again, as an ICU physician, all the time I get involved in substitute decision making. People are saying, well, what if this autonomous person is being pressured by family members? 20-30% of deaths in Canada are preceded by a decision made exclusively by a family member with no oversight, telling what they think that person would have wanted. I'm not sure why that's okay, but an autonomous person shouldn't be allowed to make an analogous decision because of fear of influence. Which again, similar to our previous discussions, I personally haven't seen. Again, a lot of people writing are people who were experts in cases where, not one judge had ever been convinced by the arguments being made. I think that's an important point to make, right? There's a lot of depth to these arguments and discussions, and it's important to play on the fact that something like 5 courts and 15 judges in Canada have heard this case and rejected those same arguments. You have to be a bit careful. You'll see selective appeals to polls where, one poll will say that 82% of Canadians support this, but only 50% or 40% support it for a given indication, and people will just want to look at half of the poll. People will often, who are advocates and advocacy positions for a given demographic, but actually when you poll that demographic doesn't agree with what this advocate was saying. And there's, I think, an increasing gap sometimes between what's being said by advocates and what's being said by the people they're claiming to advocate on behalf of. The usual killing or murder and that sort of language, I think, is a bit challenging as a provider. I can certainly appreciate that people might not be morally accepting of MAID, and I get that. But to really see that there's no difference between MAID and murder, that you don't understand, you don't really see the presence of consent or compassionate motivation of the actors as playing any role in distinguishing the term that you would use. I think that's problematic, right? Because, if you're in healthcare and you don't really believe in a compassionate motivation or that consent matters, I'm not really sure why you're in healthcare. people often make broad claims about societal values and what MAID says about that. I think that that's a bit far-fetched and hyperbolic at times. People frequently seem to cite their own opinion piece as evidence of what they're saying. So someone will write something and then cite them a previous thing that they wrote as evidence that what they're saying is true, when there's actually no data in what they said. And then when people make a criticism of a paper that's not valid and they get corrected on that, they will continue to cite their own letter as evidence, but they'll do the sort of classic post-truth thing where they'll say concerns have been raised without making it clear that those concerns have been quite conclusively addressed. And this happens in the newspaper all the time. Slippery slope legal arguments that you hear often, and again, people will, the one that I really can't understand, I will need a lawyer to explain this to me sometime, because people will repeatedly make comments that the Carter decision wasn't meant to apply to people like Carter. Like, they actually write stuff like this, as if 9 Supreme Court justices didn't really consider the facts of the case and just approved something. Again, I'm not a lawyer, but that would seem to me to be a very shaky argument to make. And then failure to understand what an eligibility criterion is versus a safeguard versus a barrier. So a lot of the comments about revisions of safeguards in Canada as being an erosion or a slippery slope. But, you know, if you're finding that people are simply not able to access something who are clearly eligible, but they can't get to people who meet the criteria for witnesses to simply sign the form, all they're doing is witnessing that you signed the form. There's still 2 people who have to assess you and make sure that you're eligible. But there are many people who couldn't even start the process because they couldn't get 2 witnesses. The rule stipulated that hospitals were preventing every employee from the hospital from doing it. And for somebody who's hospital bound and doesn't have an extended family, and the family often couldn't be a witness, that's a problem. And again, I don't want to pick on Daryl, but this would be a great example of a sentence that, you know, to me, I'm just puzzled at how this got past a reviewer, right? So this is an ethicist working in Canada. Writes the following sentence: compassionate caring, thus construed, foregrounds the values of community and our mutual responsibilities for one another. This latter position has been championed in the ethics of care literature. In Canada, the notion of care is narrowly construed, and he cites himself. So you're making a broad statement about how all of Canada feels, or all of Canadian healthcare feels about a certain concept. He's not actually a physician, as far as I know, and is citing an opinion piece he wrote as evidence of this. Again, I just don't think that's a very strong argument to make. The final thing I'll sort of turn to, because people ask me about it a lot, is growth in the use of MAID. So as you see the numbers climbing and people saying, oh, this is a slippery slope, which again, I'm really kind of confused by. So Canada legalized choice, right? Canadian system wasn't actually about like, well, you can have choice, but only if it's like 500 of you. Once it's 500, then you stop, okay? Like, you don't ration rights, okay? We didn't, when you legalized like women getting the vote, you didn't say, well, okay, women can vote, but not more than like 3% of you, okay? Because then you have to stop. You know, and maybe assist, like withdrawal of life support would be another example. We'll get there in a second. But I mean, the question is that in Netherlands and Belgium and Canada, the numbers are high. Since the pandemic started, we have seen a real climb in all of them. And of course, Netherlands and even Oregon has almost doubled in the past couple of years after being stable for some time. And really the question is the high number bad, or is the low number and the low numbers good? There are many ways to get low numbers, and you can put lots of barriers and sort of administrative challenges and access issues. Does that mean that your system is better? I'm not sure. If that's the reason your numbers are low, then that's a problem. If people are getting MAID because they're not eligible, or because they're being driven by reasons not intended by the law, that is a problem. But the pure number itself, in and of itself, I think is probably the least interesting and least relevant metric of the function of a system that I can think of. And you have to remember that nothing is ever static. You expect things to change. David mentioned the Quinlan decision in the US in 1975. So before that, it was theoretically illegal to withdraw life support. 20 years later, 40% of all ICU deaths were preceded by withdrawal of life support. Is that a slippery slope? Is that a problem? Like, should we be ringing alarm bells? Because it's climbed from 40% in the past 20 years since this study was done. You know, are we concerned about that? Well, I don't think we are, because there's a normative value that we attach, right? That we don't think that withdrawal of life support is necessarily a bad thing, but we say that MAID is a bad thing. So again, right, like really you cannot tease out the normative nature of what we're talking about from the argument itself. In Canada, we had a similar case, Nancy B. I think it was you were allowed to withdraw before that, or it was practiced, but certainly not to this degree. And in the 10 years after Nancy B., 10 years later, 46% of all SU deaths involved withdrawal of life support. So again, these are dramatic changes in end-of-life care following court decisions, far, far greater than anything we're discussing related to MAID. And yet you don't see the same level of reaction. And then to underscore the fact that things can evolve even in the absence of legal decisions, in Europe, the Ethicus and Ethicus 2 studies showing changes in withdrawal of life support. So dramatic growth in withdrawal of life support, 14% over 16 years, and a dramatic reduction in the use of CPR at the end of life, 16%, well, from 22% down to 6% in 16 years. And there wasn't even a legal decision to prompt this. So all end-of-life decision-making must be seen as an evolving process where, every culture, every society is in a constant state of evolution as we start to revisit and examine things. But there is a very broad trend towards increasing focus on quality of life and a reduction in focus on quantity of life. And so is MAID one of these weird outliers driven by a legalization and a slippery slope? I would say it's actually much more likely that MAID is just one of many end-of-life decisions that focus on comfort at the expense of quantity of life that is happening all over high-income countries and probably low-income countries too. I think that's all I had to say. I'm sorry, I hope I didn't go over time, but I am very interested to take any questions if you might have them.
Thank you very much for helping us understand the perspective from Canada. It was very